Good morning or good afternoon for those of you not on the West Coast. We're just letting our participants fill up, and once everybody's in, we will get started. We won't hold this very long because we do have a hard stop at the end of this hour, but we'll give it just a couple of seconds for everybody to get in, and then I will kick off some quick introductions. All right. I see that the numbers have stopped climbing tremendously, so it's still going up quite a bit. We're going to go and jump into this because there's a lot to cover, and we've only got an hour to do so. So thank you, everybody, for joining us today. My name is Isaac Schloss. I'm the Chief Product Officer for Contact Center Compliance. Aside from the work I do here at Contact Center Compliance, where we try to provide solutions that help you maintain compliance and solve some of your call deliverability issues, I also do some work with the PACE Association, where I focus on legislative and regulatory tracking. I can't speak this morning, I'm sorry. We're also a proud supporter of REACH, and our CEO serves on the board there. And I'm very happy to be joined by the founder of REACH, attorney Eric J. Troutman. He puts the Troutman in Troutman Amin. He is, as I said, the founder of REACH. He's a compliance expert, a successful defense attorney for those in desperate need. I think I could even call him a publisher now because, you know, I've got this great magazine here. Please be very jealous. This is a collector's item. If that's all too much, you can just simply refer to him as the Czar. Before he was publishing magazines, he often posts and still continues to post at tcpaworld.com. So if you aren't already subscribing to that newsletter, please do so. It is a very, very great tool to keep up to date with everything that's going on in our industry. Joining us, we also have Angelica Munger. I hope I said that right. She's the Duchess of TCPA World and a paralegal for the Troutman Amin firm with a knowledgeable background in marketing compliance, state-specific regulations in TCPA. She's another regular contributor at tcpaworld.com. So not only do we have two wonderful thought leaders here, but we also get to talk about something very, very, I don't even know what the right word is to use, troubling, interesting, a little bit of both. We're going to talk a little bit about Operation Stop Scam Calls. So those of you who have been following the news or not living under a rock in our industry notice that the FTC had a little bit of a big announcement in Chicago a couple of weeks ago where, you know, I'll just kick it off where Sam Levine, I believe, said that there were over 102 participants, including multiple federal agencies, all 50 states, and the District of Columbia. They've amassed more than 180 actions as part of this effort, as well as collaborating in a large educational effort. So, yeah, Eric, I'm going to throw it over to you. Some initial thoughts on this.
Well, let me just start by saying, Isaac, that was a fantastic introduction. Thank you. You're a real pro, man. So I think, you know, I always like to put things in historical context. I think everyone hopefully listening understands that outbound calling in this country, telemarketing in this country, is governed by two primary federal statutes, the TCPA on the one hand, and the telemarketing sales rule, which is actually a rule promulgated by the FTC. The TCPA, of course, can be privately enforced, and the FCC interprets that statute, has a bunch of CFRs. I think everyone's pretty familiar with TCPA, and of course, tcpaworld.com, we break down everything having to do with the TCPA. The TSR, the telemarketing sales rule, is not privately enforceable. It can only be enforced by the FTC or by other regulators. And truthfully, as a result, historically, it's gotten a lot less attention. The FTC under prior administrations has been mostly just focused on going after really, really bad scumbags, right? People who were just outright lying, people who were really engaging in some outlandish conduct. But just your regular old, you know, telemarketer that might be using robocalls or pre-recorded calls, very little likelihood that the FTC was going to enforce any of their TSR rules against the robocallers. And that all changed 2 weeks ago when the FTC announced a pretty massive sweep that has already started to demonstrate itself by way of new complaints being filed against some pretty recognizable companies we're going to talk about here in a second. But I think the important thing to keep in mind out of the gate is that this appears to represent a massive change in the strategy of the FTC from before really just going after true bad guys who are fraudsters to now basically taking an extremely aggressive approach to the interpretation of the TSR to basically prevent any outbound pre-recorded calls for marketing purposes if you're buying leads. So all of a sudden, and we're going to really break this down, don't worry, but all of a sudden, the landscape has shifted so that now not just bad guys are being pursued by the FTC, but really anybody that's buying leads and using pre-recorded calls to make outbound marketing calls. And we'll break all this down here in a second. It's a really big shift. And we don't know how far the FTC plans to push this, i.e. how many new cases are we going to expect to see here in the next few weeks and months. And it'll be really fascinating to find out. But in the meantime, we really got to start thinking about solutions.
Now, as we go through this, everybody, I do want to let you know that, we do plan to make this interactive. So if you've got questions, please drop them in the Q&A box. Also, while we do have a brilliant attorney on this call, this is not legal advice. We're sharing our perspective. And as Eric mentioned, we will be talking a little bit about this. If some of the names of the parties that were involved come up in this, please know that we are mostly speaking to or entirely speaking to what is being alleged. We're not necessarily speaking on behalf of them. So please, take it with a grain of salt. The prosecuting party is allowed to kind of make accusations however they want, word what their opinion is. So if we quote something that was said or paraphrase something that was said, note that we are speaking from what has been stated by the FTC. And just very important to get that, because there were some pretty damning topics that were talked about, but this really seemed to go all around consent farms and statements. And I'm reading directly, if you see my eyes shifting, I'm reading directly from the transcript. They used the term luring. They were luring customers with offers for jobs and rewards. And they talk about tricking and all these things. So, what is a consent farm in the eyes of the FTC?
I mean, that's a really tough question. And I know Angelica was going to kind of break down, at a high level, some of the the statements there, but let me kind of, again, just to frame out, and I will answer the consent farm question, just to frame out. So there are a couple of different pieces that we're now seeing in the complaints that are being filed by the FTC. And you've highlighted a really important one, which is the consent farm animal. We'll talk about that front and center, but I just want to kind of give you all the layout, right? We've got consent issues, which is a major piece of this. And we're going to talk about that in some detail, consent issues, but we also have dark patterns, right? Which is the way a website is laid out, where a consumer is basically being tricked into going down one side or one funnel when they could have gone through a different, more favorable opportunity for that consumer. And they've been tricked, essentially duped into doing something else. We'll talk about that a little bit. It's also important that we're talking about disclosure formats that are not proper, right, in the eyes of the FTC, because there's not, the font is too small, it's too light against a background. All of these things that you see, above the button, below the button, and really importantly, the language on the button, for instance, just saying continue as opposed to saying continue and accept terms, right? All of these things are finding themselves in complaints, and they go back to the idea of a consent farm, right? So when the FTC is using that language, and they're not, understand, they're not breaking this down for you, right? We're trying to break this down. We're trying to give you the pointers here based on what they're actually doing versus the words that they're using. So they say consent farm, that appears to be shorthand for companies that are gathering, right, like most lead generators do, consent for multiple parties to call on a single lead, using potentially, right, deceptive means, tricking people into coming into their website, using disclosures that use the word continue but don't have an asterisk, or don't say continue and accept terms, or don't have a box, right? These things that are pretty common, and there's no set standards, right? No case law has developed and said this is exactly what you have to do or what you don't have to do. And so the FTC is stepping in and basically telling courts, hey, look, we, without an NPRM, without setting forth a rule, without doing anything formal, we're going to come in right now. We're going to say that because all of these, best practices, the standards basically that Reach has put out, which would require black and white, clear disclosures, but that really have not been adopted industry-wide, as everybody knows, right? Essentially, the FTC is saying the failure to use good, transparent, clear, black and white, these disclosures, that is itself a violation of the TSR, which is a really big deal in and of itself. But of course, there's another layer that we're going to get to here specific to just whether or not consent can be transferred at all. So the consent farm piece, the complaints that we've seen so far are focused on this holistic review of how are these websites operating, how are they capturing consent, how many people are on these disclosures, right? All the things that you've heard me talk about from the FCC, not the FTC. The FCC is considering all of this in the NPRM proceeding under the TCPA, but now we're seeing the FTC basically jump ahead and bring enforcement proceedings focused on these exact same issues under the TSR. So it's really fascinating.
So, I know one of the statements that was made that it was that a single unwanted call is one too many, and they want to crack down on illegal telemarketers. Now, there's a difference between illegal calls and unwanted calls. So I found it interesting those were the same sentence. Angelica, when you were going through this and when you were kind of listening to the call and getting the feel, I mean, I'm hearing a lot of strong language being used, and I heard a good mixture of clearly things that appear to be evil, bad practices, and then maybe some people who just could have done things a little bit better. I mean, what are kind of your thoughts on the, especially the unwanted versus illegal calling?
Yeah, no, I'd have to agree there with some language. I feel like a little theatrics in there as well. They were really coming on strong. And so I think that was part of my confusion listening in as well, because I do feel like there are probably some, bad actors in the space. But to your point, there's also a lot of people out there that are trying to do the right thing. And potentially maybe they're just unaware of the requirements around like, proper disclosures, like the consent language that's needing to be there present. See of what a consumer is actually opting into as well. So I don't know if maybe some, consumer confusion is maybe driving the narrative of like the unwanted and illegal phone calls, where it could just maybe be a little bit more transparency for the consumers.
Now, the term robocall came up quite a bit. And, I know, Eric, you and I were exchanging emails about that the other day, and I have a little hard time with the FTC talking about robocalls because I'm not sure if that's actually defined as part of the TSR, at least not from what I have seen. So I know that there are many interpretations of what that means. I think most time when I read it in any specific law, whether we're talking state or federal, it's pre-recorded messages. But, then they start talking about avatars and whether or not those are robocalls. I mean, how wide is this scope? Is this, we talk about, again, unwanted calls is too much, but then we talk about robocall operations. So are they mixing the two here?
Yeah, I mean, the FTC operating in this space is really, in my opinion, it's pretty repugnant because really it's the FCC's province to look at telecommunications in this country. The FCC has a much more sophisticated apparatus, a lot more expertise. They're much more measured, right? I mean, they've got this formal NPRM proceeding. They're seeking comment. They're weighing both sides. They're trying to come up with what's the right solution on balance for American businesses and American consumers in light of all these various concerns. The FTC has none of that, right? They just come out and it really was like, it's theatrical. Like they just want some attention. They just want to get out there and like show people they're doing something, which don't get me wrong. Look, I respect it, right? Obviously, I started Reach because we want to stop 1 billion unwanted calls a month, right? Like that's our job. That's our goal, is to get industry together to stop the abuses in the lead generation industry, which there are, right? Like, so I'm aligned with it. But when they come out with these ridiculous proclamations, like this LinkedIn thing, let's just talk about this LinkedIn thing because it ties back to your robocall statement. So on top of all of what we're talking about with these new complaints and with the statement that they did 2 weeks ago as part of the sweep, right? All of which directionally, I think most people saw coming. We knew that they've been bulking up for some time, hiring new attorneys, hiring new staffers. There's been, certainly some signaling to industry that, 1-to-1 consent was going to be required. All of this, I think, made some sense. And then out of nowhere, last Thursday, the LinkedIn account for the FTC, which, I mean, I'm wondering if it was hacked. I'm wondering if this was just some goofball that wasn't supposed to do this, wasn't authorized to do it, submitted, it would be cool if we got it flash up on the screen, a LinkedIn post that said that consent cannot be transferred if you're going to use robocalls to contact that number. And so and let me just say that again, right? Consent cannot be transferred, period, if the lead buyer, right, the seller, is going to be using pre-recorded calls to contact the consumer. It doesn't matter if the seller's name was on the disclosure. It doesn't matter if it was a one-to-one disclosure, right? The website generates a lead specific to, whoever, Geico, right? And then it's transferred to Geico, and then Geico makes the phone call using a pre-recorded voice, like, "Hi, it's the Gecko saying hello. Would you be interested in Geico?" No, according to the FTC, that is a violation of the TSR. That has never been a position that's ever been taken before. And it begs several questions, right? Because again, this is a LinkedIn post. This is 2 lines in a LinkedIn post in social media. One, what are we supposed to do with that? I'm sorry, are we supposed to give compliance advice, FTC? I don't know if you're listening or not. I say this with love in my heart, but seriously, as a compliance attorney, a lawyer that tries to keep people safe, am I literally supposed to be giving compliance advice, telling people to change their business practices based on a LinkedIn post? Can you help me out? Can you give me something a little bit more solid, pretty please, with sugar on top? Because I'm going to tell you, I talk to clients and they're like, "Dude, it was a LinkedIn post. Are you serious? You want me to change what I'm doing right now because of a LinkedIn post?" And it makes it really tough for me, I'll be honest. Okay, so that's issue number 1. Like, what importance should we give to a LinkedIn post, right? Let's just let that wash over us for a second. Second, in this LinkedIn post, the FTC did not cite to any authority, did not actually explain what it was talking about, right? When it says robocalls, and this goes back to your original point, Isaac, what is a robocall? Now, it won't shock anyone to hear this, to know that under the federal law, there is no statute, there is no regulation, there is no declaratory ruling, there is nothing that defines the term robocall. The term robocall is like a stranger to the law in the United States. It doesn't exist. It's not a real thing. So what is regulated in the United States is pre-recorded voice messages, artificial voice messages, calls made using automatic telephone dialing systems, telephone solicitations to numbers on the DNC, and then the use of caller ID information and anti-spoofing rules. That is all covered in black and white to a certain degree. In many different enactments, but robocall, that word robocall has never been used. It does not exist. And so it's very inconvenient when the FTC, an actual government regulator that we're all supposed to really listen to, goes off and uses loose language like robocall, which has no fixed or defined meaning, and then suggests that you can't do something that everybody thinks you can do, which is purchase a lead that has your name on it so that you can then make a contact using a robocall, whatever that is. And so the ultimate issue today, right now, that we're talking about is the FTC has now decided it's going after marketers, right? And it's going to go after the lead gen industry. Like, that is clear. That is the direction that it has given. And it is empowering itself in real time using things like LinkedIn posts to determine that we are going to say from now on that if you bought a lead and you used a pre-recorded call for marketing purposes, that alone is a violation of the TSR. And that's crazy. It's crazy, 1, because it's incredibly aggressive, 2, because it's not true. Like, that is not what the law, the CFR, says. In fact, it can only be interpreted, in my opinion, the complete opposite, which is that a seller can obtain, that word obtain is in the definition, can obtain the consent from a third party. Right? The word obtain wouldn't be in there if it didn't encompass third parties. And that's the way courts have held. And that's the way, lawyers like me would look at this and interpret the statute. So I understand now that the FTC wants to put everybody on notice. They want to say, no, we as an agency, we disagree. Now, again, problems with this. 1, you're supposed to do something as an agency to issue this as a formal ruling, like actually get people who are authorized to make the statement, put it in writing, disclose it through formal channels like the Federal Registrar, and give people notice, right, that this is going to be the new position that you're going to be taking. Instead, we're doing this via LinkedIn post, and we're doing this, regulation through enforcement activity. And it's, in my opinion, it's gross. In fact, we're thinking about having Reach, and we have a meeting on Friday. We're going to talk about this, seeking a TRO, seeking a preliminary injunction to prevent the enforcement of any action taken on a LinkedIn post. I feel pretty good about this. Like, I feel if I go into front of a federal judge and I say, "Judge, look, we need 90 to 120 days for industry to, respond and change its practices in light of this brand new position, never before taken and displayed one time on a LinkedIn post from the FTC. Can you give us a little time, Judge? I feel pretty good that federal judge is going to give us that, if not something much better. So we're definitely contemplating that. Anyway, I know I just went on a soapbox, but it really frustrates me when an agency does something like this, because again, I'm supposed to be giving legal advice. I'm supposed to be able to tell my clients, like, here is what you do to be safe. And now I'm in a position where I sincerely don't know what to do. And I hate that. Like, those words never come out of the czar's mouth, right? I never say, I don't know. I always know everything. That's part of being me. But right now we're living in a very dangerous environment where the FTC, again, has just kind of given itself a cloak, given itself a mantle, and is just running around out there about to swing a sword, and we don't know who it's going to swing at next.
Yeah, and again, the reason we're zooming in on the definition of a term like robocall is simply because it's hard to have a rule, or really it's hard to play a game if you don't know the rules. And that's, from a contractual perspective, take a step back, especially those of you that are out there that are at a senior level in your business. Whenever you're reviewing a contract, one of the first things your attorney is going to do when they're reviewing a contract is say undefined term. And they're going to highlight something saying, we can't agree to this because I don't know what this means in the context of this agreement. So, when everybody in the space, whether it's contact center compliance, it's Troutman and Mean or Reach or Pace or whomever is looking at regulatory changes. One thing that I know always makes my eyes roll is when I see something like call spoofing or robocall. I'm like, okay, great. Let's see what they're going to call it in this state. Let's see what this rule is going to be. So while we can always all pretend that, well, we all know what robocalls are, I've got one question right here, and this is not meant as a dig at the person that asked this question, but they asked the question, are auto dialers considered robocalls if it is not a recorded message, but a real person on the other end? Now, my initial read to that is based on the understanding I have of what a robocall is, where it is defined. No, an auto dialer is not a robocall just because it's an auto dialer. But if the term's not defined, what is that up to a jury? I mean, what are your guys' thoughts?
Well, again, a robocall should never be up to a jury because it's not a component of any law. So a jury would never be asked, was this a robocall? But kind of from a disambiguation standpoint, there is certainly, I was going to call it precedent. That's not correct, but there's certainly like definitions out there that would include auto dialed calls as a robocall. In fact, the FCC has come very close to basically saying any automated call is a robocall. And they've lumped it together in assessing consumer complaints about quote unquote robocalls. And they've essentially treated pre-recorded calls and auto dial calls the same. Now, that's the FCC, which again did not make the pronouncement. It was the FTC that made the pronouncement. And what's fascinating is if you look at the TSR, unless I'm missing it, I'm the TSR, the TSR, does not define robocall, but it also doesn't look at automated technology. What it looks at is pre-recorded voice technology. And so the best that I can fathom, right, and no one knows for sure, the woman or man that was behind the LinkedIn post was presumably, when they said robocall, what they were presumably talking about was a section of the TSR that defines abusive conduct that looks at the use of a pre-recorded voice. Only a pre-recorded voice. Now, this is fascinating because the TCPA, as you know, governs pre-recorded and artificial voice and auto dialers, right? So if you want to use this loose jargon, under the TCPA, a robocall, right? Again, not defined, not a real thing, but if you want to use shorthand, I suppose, would include all of that. Under the TSR, right, the only regulated technology, again, looking at robocall, is pre-recorded voice technology. And certainly Avatar, right, would meet the pre-recorded voice technology standard. The FTC has already said that. And the FTC has now really taken a big swing at Yodel in a DOJ proceeding. We can talk about that here in a second, basically saying that its platform is definitely going to be a robocall. But kind of, finishing the thought, the LinkedIn post, right, if this is a new official statement by the FTC, which remains to be seen, in my opinion, what that means is that you cannot use a pre-recorded voice call at all under the TSR for marketing purposes. This is all about marketing, okay, for marketing purposes, if you bought that lead, period. Doesn't matter, understand, Doesn't matter how good the lead is, doesn't matter if it's perfect, if it otherwise complies with all the standards we talked about earlier, right? Those are two separate issues, right? This is a waterfall, right? So assume that everything else is perfect. Assume that you're named, assume that the consumer was real, they went on the website, they knew what they were doing, they clicked the button, they agreed, it got transferred. According to the FTC's ridiculous LinkedIn post, you still cannot use that pre-recorded voice contact. Now, I will say this is actually consistent with the REACH standards, which does not permit the use of a pre-recorded voice as the initial contact strategy on a purchase lead anyway. So although I am, somewhat criticizing, and I am, the FTC for taking this strange kind of baseless position on LinkedIn without any justification or any formal ruling, I will note that REACH actually already had that standard in place. So that is, I guess, some good news for those who are REACH members. This is not going to really be a stunning change for you, but I think for 98% of people in the industry, like, this is a real change. It's a really big change, and I don't think people saw this coming.
I think one of the things that frustrates me about this is when you read this, you see clear abusive, fraudulent behaviors, at least based on the accusations that are being made. But then there are other places where you say, okay, well, I don't even know, maybe they didn't have the right consent language, or they didn't have the right number of parties, or maybe they just abused it and they should have limited their list to 50 versus 500 or something like that. So there's a lot of gray area, a lot of questionable practices that are in here. But I think one of the important things to point out is something that was just said, was that if you're already adopting some sort of self-regulatory set of rules, you're going to be in a better position right away, because you're trying to get ahead of this. They're cracking down on the companies that, in some cases here, it's companies that might be trying to use a gray area and they're just acting irresponsibly, versus ones that are clearly being fraudulent. There's a lot of questions being asked about pre-recorded voicemail messages, and based on, again, what we've talked about with what the understanding in general is of a robocall, if it is a pre-recorded voicemail message, that is still a robocall, at least by again, we're talking TCPA versus TSR, but from a TCPA perspective, hasn't there been some case history where somebody has called, left a pre-recorded message, and they've had some problems because of it?
Yeah, and we're gonna have to get you talking more, Angelica. But the short answer is yes. So again, under the TCPA, there's very little case law under the TSR, understand? And that's part of something that the FTC is taking advantage of, is that because there's so little case law, the FTC is basically saying, hey, look, we can define it however we want to define it, right? It's our reg, and we are going to say, our reg, you can't transfer consent, right? Okay, whatever. Under the FCC, again, much more rational lately agency, and under case law under the TCPA, though, yes, a pre-recorded call, right? Most courts will find that a pre-recorded call includes a pre-recorded voicemail, and that includes ringless voicemail. In fact, ringless voicemail has been repeatedly found to be, both under the FTC's TSR and under the TCPA, a call that is actionable and is a pre-recorded call. So again, I hate to use that robocall lingo, because I just think that it has no place in the discussion, because it's not an actual word that matters in the law. To the extent you're looking for a definition, yes, these pre-recorded calls would be treated as these pre-recorded voicemails would be treated as pre-recorded calls under the TSR, and ergo, I suppose, would be a robocall in the FTC's jargon.
Okay, so again, trying to take a step back from this, and I'm going to put this one over to you to start the discussion, Angelica, is the talk about obtaining that consent and how that consent is obtained. A lot of businesses don't run their own websites. They don't run their own products for gathering consent and things like that. Even if we're talking about a one-to-one relationship, which I know has been a hot topic for quite some time, if I'm an organization and I outsource my marketing to a company, and a company goes out and says, I'm just going to use the example Geico since they were used earlier. You go to this website and you say, I'm interested in a quote from Geico. Yes, I consent to getting those robocalls. Based on what they were talking about, are they saying that even that is a bad idea?
Well, I think if you are outsourcing your marketing, you as a company are still responsible for making sure that that is compliant, right? And that you're reviewing the marketing that that company's putting out for you, that it's, you know, it's cohesive with your requirements and your policies and practices. So I think, I mean, to your point, I believe like what they're saying is, yeah, you cannot do that, right? That's a third party that is in between you and the consumer. And essentially they're saying like, yes, no, that's not one-to-one.
Yeah, right. Yeah, the buzzword now is direct, right? That's the buzzword. It's been kicked around in the FCC proceeding, the NPRM, and it makes me chuckle because I remember 3 months ago when I first started flagging this, hey guys, direct consent. This is what they're after, direct consent, public knowledge, the AGs, you know, everybody's talking about direct consent. Everyone kind of shrugged it off and was like, oh, Troutman, oh, the sky has fallen. Okay, Chicken Little. And I'm like, guys, like seriously, this is a big deal. And everyone shrugged off. Now, look at this. Here we are 3 months later. The FTC, again, on LinkedIn, but has just come right out and said, right, consent has to be provided directly. So Geico.com, you can get consent on Geico.com. That's fine. That's still valid. Geico.com, Geico could then make an outbound telemarketing pre-recorded call, and that would be fine. But if Geico bought that lead from anybody under any circumstances, no matter how good, how pure, how clean, that is now a violation of the TSR, says the LinkedIn post, right? And I want to emphasize that I think it's important for people to understand that yes, under the TSR, we're only talking about FTC enforcement actions, which although the FTC has bulked up and added like 200 lawyers or whatever, and now it's like the super Hulk of federal agencies, you know, they're still only going to be able to police a limited number of people. So I know there's going to be some folks out there that are hearing, hey, look, you know, what are the odds of the FTC coming after me? It's a dangerous mindset, but I understand that that's, you know, some of the calculations people have in their business model. And hey, it's only pre-recorded calls, so we can keep safely selling and buying leads because we can just pivot to some other, you know, channel. Just keep in mind, guys, going back to the FCC, that NPRM that I've been jumping up and down about for months and months and months, right? The FCC and the FTC almost always harmonize, almost always. So if the FTC is taking this position that consent has to be provided directly from the consumer to the seller, directly from the consumer to Geico, the FCC, especially with 28 AGs weighing on them, especially with the very powerful public knowledge, the very powerful NCLC weighing on them, and really only with a handful of participants pushing back, in my opinion, the FCC is very likely to adopt what the FTC is doing. And that means not just pre-recorded calls, that means any, right, call to a number on the DNC, period. Even if you're dialing manually, you can no longer use a purchase consent if the FCC adopts this standard. In addition to all pre-recorded calls, and in addition to all auto dial calls, right? All of that would fall within the realm of the FCC. If the FCC adopts what the FTC is doing, which might be the end game here, right? We're talking about a massive shift, and basically lead generators have nowhere to go, right? These leads are not going to be, they're not going to be viable anymore, at least not the data leads, and probably not the warm transfer leads either. So it's a very, very significant thing. Even if this is just the first step toward, you know, the Armageddon that I've been, I don't want to say foretelling, but been warning about, this is the first step, and we're staring it right in the face right now.
So I'd like to shift a little bit and talk a little more into the specifics of what happened. And there's a question that was asked that I think is a good segue into that. The question was asked, you know, what if a first party opted into my site? Is automated voice call okay? Now, I'm going to start that answer off by saying, in my personal non-attorney opinion, they're on your site, they're opting in. That should be okay, but asterisk, make sure that you are doing everything properly with capturing that consent, because some of the allegations in here were around how that consent was gathered. So you've got to have a good attorney reviewing your compliance plan. You need to make sure you're regularly reviewing it. Don't set it once and then you're okay, you know, 10 minutes later or 2 years later, because things change really quickly. But, you know, why don't we talk about some of the mishaps or some of the allegations that were made around how consent was gathered in these sites?
Yeah, but why don't I start also by going back to the question, right? You know, he said, if it's my website, can I use pre-recorded calls? And the answer is maybe. Because the question is, who are you, right? Now, if you are Geico, if you are a provider of a good or service, yes, you can use pre-recorded calls. But if you are a lead seller, right? And you are not an actual provider of a good or a service. You're just going to connect people, and you're going to, so they come on to getlowinsurancerates.com. That's your website. They fill out a form that lets lowinsurancerates.com make outbound calls to them. You then make that pre-recorded call. I'm going to tell you, there's a risk that the FTC would say, you don't get to make that call because you're not a provider of the good or the service, right? So that is a risk right there. Secondarily, let's assume that you are allowed. And again, I'm not expressing an opinion on this. This is just something for you to think about and for you to get a lawyer to think about too, because it's a really interesting conundrum. And again, developments are moving very quickly here. Everything's a little bit gray. But the second piece is assuming that you're allowed to do that and you generate that lead and you warm transfer, right? Now you've got to be asking yourself, did this person you're warm transferring to, did they have to be named in that disclosure as well? And does this warm transfer constitute a form of a transfer of a consent that's not going to be permitted now under the TSR? It's really, really difficult to kind of foresee exactly how this is going to break down, but we should all just be orienting ourselves to understand that what the FTC is really after right now, let's not kid ourselves, is destroying the practice of selling leads that are leading to robocalls. And again, by that we mean, I believe under the TSR, pre-recorded voice messages. So just keep that in mind, okay? Now, putting all that to the side, and putting it in my screen, I'm putting it on to Angelica. Goodbye, I'm just gonna put this over here. We're not gonna talk about that right now. The other big set of issues, right, which you are wise, Isaac, to not overlook, because it's very important, and we're going to pick on the Viceroy complaint here, looks at what the format of consent needs to be. And you guys, those of you that are big followers of the Czar and of Angelica and the Duchess, you remember a case called Berman that I made a big deal about on tcpaworld.com. And we did a bunch of webinars. I even did a webinar with dmc.com on Berman. And I said it was a really big deal, because in that case, the Ninth Circuit Court of Appeal looked at a Fluent website, and we all know Fluent, right? And they try to be pretty compliant. They're pretty sophisticated. They've got in-house counsel. Like these are not dummies. And looked at one of their forms and said, on appeal, right? Not the lower court, the higher court ruled as a matter of law that disclosure was not enforceable, and that was stunning. It was a stunning change, and it looked at a couple of pieces of it. One kind of holistically, the court basically said, look, this is tricking the consumer. The consumer just sees the continue button. They think that by pushing the continue button, they're just confirming basically that their zip code is clear. Underneath, right, in fine, very small print, yeah, sure, they're accepting some additional terms, but that's not clear to the consumer, right? And several pieces got kind of brought out of that. That one, the button has to give that consumer notice that something legally operative, something final and important is about to happen. It's not just like another step in a flow. I'll just click it and we'll move on to the next page. No, this is going to have a legal effect, because a consent, or an arbitration in that case, is a formal contract, and the consumer has to know that they're entering into that formal contract by pushing that button. And the words used to convey that this is taking place have to be clear. The consumer has to know, right? You go onto Amazon.com or onto Disney, right? And they've got those little terms and conditions links, and there's like 150 pages of terms, and they say we're going to take your firstborn son, and 6 generations will all work for us, and we own you and your privacy forever. These are enforceable. Why? Because they have this nice little elegant form. It says, I accept terms, click, right? Everybody knows that they're making a deal with the devil. Nobody reads that 150-page form, but everyone knows that they're agreeing to something, and that is what makes it binding. The forms where the consumer doesn't know that they're agreeing to something, right? Those are the forms that are not going to be enforced. The forms where, rather than the clear statement that I accept terms, are too small, it's underneath, you can't really see it, there's a big gap, it's hidden, right? Any of these things are going to make that form potentially unenforceable. And importantly, the elegance of the form, or the lack of distractions, is very important. So it's a weird thing to say, but courts are very concerned. Again, you think of the examples of Apple Plus or Disney Plus, or I don't have any of these stupid services, but you know what I'm talking about, right? You go online, and these things are very elegant. They're very clear. Like the page, it's just like Spartan. It's just, here are the words, here's the button, you know what you're doing, right? Compare that to your average lead gen form where, right, like getting the consumer into the funnel involves all kinds of distractions and buttons and click here, and this is great, and blah, 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 right? And so basically the courts are somewhat allergic to that. They don't like that. They consider that to be what's called a dark pattern, which is essentially consumers being tricked into entering a funnel they wouldn't otherwise enter into. And in the Viceroy context, I mean, really some very specific examples appear in that complaint, and I put them up on TCPA World for you to take a look at. But when you do look at it, you'll see, for instance, in that complaint, it was alleged at least that there was 2 different flows that the consumer could go through to get the information, which in that case was job offers, right? And according to the complaint, the job offers were available to the consumer regardless of whether or not they provided their contact information and accepted a terms and condition, right? They could get that without going through that flow. But the way the website was designed, it was like so prominent, right? Click here, big spots for your phone number, your entry, the disclosure, and only like way below, little tiny font is like, click here to skip, right? Click here to skip. Anytime you're using a click here to skip that's really, really small and down below and hidden away from the consumer, you've got to be asking yourself, is this tricky? Am I tricking a consumer? Is this a dark pattern? Because the FTC in that Viceroy complaint basically said, yes, it is. And I'm on record saying, I don't disagree, right? I mean, if you are intentionally driving that consumer to something, with something that's 10 times bigger, and then a little tiny, very small gap down, small print, here's the other way you can get in if you can find it. It's a game, man. That's a game, and that's not consumer friendly, and you're going to get hammered. And truthfully, I'm not going to have very much pity on you. Now, if you're somebody that's just buying good leads and trying to contact people that really want to hear from you, I don't think you're a bad actor. That's why I don't like this LinkedIn thing that the FCC did. But if you're engaging in dark patterns, first of all, I'm not going to be your lawyer. And second of all, I'm not going to really pity you very much. And I don't think very many people will. So clean up your act, right? Look at this Viceroy complaint and take that piece very seriously.
So there was a question about auto dropping a voicemail, and I'm not sure if that means ringless voicemail or if that means just pre-recorded messages being played to the voicemail. But there's questions about that in response to a lead inquiry. And I like the word inquiry because there are certain rules in the TSR about existing business relationships. There's inquiries versus purchases. But then there's also preemption at a state level for some things when it comes to EBR and inquiries. And Angelica, I know you do a lot of state level tracking as well. So, if somebody asks the question here, well, what about somebody who I've got an inquiry? Am I safe to auto drop a voicemail? What are kind of just off the cuff thoughts on that one?
So, I mean, with most states, you're still going to have consent. You're going to have prior consent. If you're going to use an automated type message, a lot of them are pretty clear in that guidance. I don't know what they mean by an auto drop of voicemail, if that's like a ringless voicemail, and that's what they're speaking of. And I think, Eric already spoke to that earlier, that those are just kind of like a big no-no. But as far as an automated response to an inquiry, you're going to need it with the prior express consent of that consumer.
Now, do we want to even get into how AI and there's AI, there's soundboard, there's avatar technology, which is a little bit different than that. There's the voice modulators that can just simply change your voice. Now, I would hope with at least that last one. Because I'm having a heavy BPO background, and I've had contact centers in India and the Philippines and all over the world, as well as the US. Companies have pitched, hey, this can help clean the accent out so it's easier for people to understand. I don't think that's a pre-recorded message. That might fall into issues with other things, but that's not quite a pre-recorded message. But what about AI? What about soundboards? Those are getting asked about a lot here.
Go ahead.
Good. Go ahead.
I was going to say on the announcement or conference that the FTC held, they did specifically come out and say soundboard technology is a robocall and will be treated as such. So that's from the FTC. That was again their statement around that. But to your point of helping like clean up languages for it to be more fluent for people to understand, there are actually some state laws around that as well. Again, you'd have to dig into each 50 state law to see what those exact requirements are, but there's some that actually prohibit that.
Yeah, and let me just say the FTC's statement on soundboard is actually not new. that the FTC has been taking that position for a while. There's some informal guidance going back a few years on that subject. So, that's not one where I'm going to come down to the FTC and say, what are you doing? There was no notice here. I think anyone that's paying, careful attention to the commission knows that was, at least, again, informally a policy position. But again, I want to emphasize, I think it's very interesting. The TSR only looks at pre-recorded calls. It doesn't look at artificial voice or auto-dialed calls. So under the FTC's authority is only pre-recorded, true pre-recorded calls. Now, Avatar, right, is pre-recorded. That's why a soundboard is going to fall within the TSR's parameters. But AI, or a voice enhancement, or a voice that is automatically generating in real time during the communication. Again, I don't want to give anyone, ideas here necessarily, but technically that does not appear to meet the letter of the TSR. Now, would I put it past the FTC to just say, well, pre-recorded call means all this other stuff too? I would not, and they may. But, for what it's worth, as written, that's not what the TSR seems to cover. And again, I want to continue to draw this distinction because the FCC and the TCPA is broader, right? And so it would cover, at least potentially, the AI or the artificial voices. All of these kinds of chatbot features would fall under the FCC's province and not under the FTC's, at least in theory. But again, FTC is running a little bit amok right now, so you can't rule anything out.
Somebody asked a question about, having this retroactively applied to leads they purchased in the past. And I think it's important to understand that this is not a new ruling that has come out. This is not anything new that has been codified, at least to the best of my knowledge. This is, as they talk about it, ongoing investigation. So I feel like, and that's part of the concern here, is that it seems in some cases like some of the rules may have changed, especially that LinkedIn post. So I think, yes, retroactively, we've got some risk here, right?
Yes. Right. And that's the insane thing about what the FTC is doing. Okay. And stay with me. Usually under the law, if Congress passes a new law, it's not retroactive. If your state legislature passes a new law, it's not retroactive. Right. Now, if a law is already on the books, but it is unclear, and a court comes in and interprets that law, that interpretation is treated as retroactive. In other words, that's what the law always said. It just wasn't clear. And now the court has made it clear what the law has always said. Now, the FTC acting alone does not have the power, absent a formal declaratory ruling or a formal NPRM proceeding, to dictate unilaterally what the law has always been. But what this FTC has done in the LinkedIn post is it's put everybody on notice that its position for enforcement is that this is what the law has always been. And so it's going to go to court, as it already has. And it's going to tell the judge, dear judge, this is my reg. I'm the FTC. This is my reg. This is how I interpret it. This is what the law always was. Find accordingly. Now, ultimately, judges in this country, as you know, are very powerful. It is the judge and the judge alone who will determine whether or not the FTC's position is valid and correct. But if the judge determines that it is, then yes, that is retroactive, right? And that's why everyone has to be very thoughtful right now in terms of kind of what steps they're going to take. Now, the only thing operating in your favor is arguably under the TSR, it's different than the TCPA. Under the TCPA, it's strict liability. Under the TSR, arguably, it is only knowing violations can be pursued by the FTC. Now, the FTC might disagree with that. If their lawyers are watching, they say, no, that's not true. But that is something to keep in mind. And you'll see in every single DOJ complaint, they try to establish knowledge by demonstrating all the things that company knew or should have known based upon previous FTC action, et cetera, et cetera. So this LinkedIn post, right, is actually part of a broader game by the FTC to imbue industry with knowledge. And of course, we all fell for it, right? Because here I am amplifying their message. I'm like a tool. I'm a tool of the FTC. Even this webinar makes me a tool, right? Everyone else attended. Oh, you attended Trumpan's webinar, so you must have known, right? Like, this is like how ridiculous, from a certain perspective, what the commission is doing really is they're trying to take this policy position and then they're going to try to go to court and have the court rubber stamp it. And that's why when I was saying, look, Reach is going to get involved here, we're going to intervene. Like, I don't think the industry can just roll over and let someone like Viceroy, right, like the small company that really doesn't have any money, get steamrolled, which they probably will, and have a court rule for the first time ever that yes, the FTC's retroactive interpretation of its reg is correct, and therefore all of you who have ever bought a lead over the last 4 years who have used a pre-recorded call, now you have violated the TSR, right? That's pretty bad. I don't think industry wants that to happen. So again, it's something we haven't decided on this yet, but we're looking at potentially putting together a legal defense fund, doing this, just really rolling up our sleeves, going into federal court, suing literally the United States of America, and to prevent any retroactive application of this new policy position. I know it's crazy, right? But I mean, that's really the only course, because otherwise the FTC is going to pick, as it's already doing, it's going to pick very intelligent lawsuits. It's going to bring them in front of judges that are going to be friendly to the FTC's positions, and it's going to start building case law, slowly but surely, retroactive case law, that these consent records, right, are invalid. And once that starts to happen, now everybody's at risk, right? Everybody is facing a massive potential exposure to the FTC. And I cannot emphasize this enough. The FCC has their NPRM proceeding going on right now. And what do you think will happen if even a single court adopts the FTC's position on consent? That's going to go right to the FCC. And there's a very high likelihood the FCC is going to do what the court said, right? And the FTC knows that. And that's what this is, like, that's what I'm saying. Like, I'm trying to give you guys all the big picture, right? Everyone lives in the small picture. Oh, it just says robocalls. Oh, it just says this. Oh, it's not a big deal, right? Everyone's got this like hardwired, what seems like impulse to just like dismiss this stuff. And I'm like, guys, there's a bigger picture afoot. Like, trust me, this is all, it's just part of a larger game. And I'm trying to help everyone to understand that.
So, I just want to point out one of our audience members mentioned that this is also on their Twitter and Facebook, the FTC. So they're using all the big socials to get that out there, not just LinkedIn, which I often look at as kind of the minor in the social media space. But as we're reaching the end of our hour here, a question that's been asked, which I think really gets to the heart of this, is how existential is this in reality for the top lead generators, or the lead aggregators? Do they need to pivot given the current models? Do they need to look at just a completely different business model? What steps should people be taking right now in response to this?
Yeah, so if you're a lead buyer, right, you have got to be considering. I'm not giving you legal advice. And again, I'm telling you, a LinkedIn post and apparently a Twitter and a Facebook post, to me, is not binding law, and no court has made any kind of definitive ruling. So I'm not saying it's black and white. I'm not saying you have to take steps. But if you're buying leads, you got to be thinking, do I want to take the risk and use pre-recorded calls to contact a purchase lead at this point, right? And if you're selling leads, and you just heard me say that, you got to be thinking, okay, there's going to be at least some segment of the population that's no longer going to buy leads if they're planning on using pre-recorded calls. Now, hopefully from a lead generator perspective, this is more of a keep this in mind today, because it's more of a lead buyer pivot moment where the lead buyer directionally needs to stop using pre-recorded calls and move toward live voice channel or text message, right? To me, that's today's call to action, today's major concern. The lead seller should understand that maybe their market is going to start drying up a little bit. Maybe pre-recorded calls are no longer going to be an attractive channel for a buyer, and they should think about how they can adjust in light of that reality. But to me, the bigger play, as I keep coming back to the FCC, right? Because FTC proceeding under TSR, as we just talked about, it's not existential. It takes away one contact channel. That's what happens. It takes away one contact channel. Does that suck? Yes. Is that right? Probably not. But that we just have to live with that possibility right now. But when you talk about the FCC, understand it has a much more powerful bazooka to aim here. And now we're talking about destroying pre-recorded calls, artificial voice calls, auto dial calls, and probably most importantly, right, calls to numbers on the DNC. Understand that if the FCC adopts the FTC, there is no way that you can sell a lead for somebody who's on the DNC list, the national DNC list. 60% of all numbers are gone like that. that lead can no longer ever be sold again. Set aside the fact that even if you sell the lead, they have to do it manually, and there's going to be a bunch of restrictions on how it can be done, and you can't use a pre-recorded voice ever again. DNCs are gone. They're gone. So this is a massive moment. And again, what percentage of lead suppliers survive this? Is there a massive pivot toward driving to site, right? I mean, ultimately, you can imagine the post-NPRM world, right? The post-FTC, TSR, LinkedIn world. Now we're talking about a premium being put on driving consumers to websites, right? Going back to geico.com. Yeah, you can no longer sell a lead to Geico, but maybe you can sell services designed to get consumers to go to geico.com, right? And you guys are masters at that. And that's the obvious pivot. From my perspective, that's the obvious pivot. Now there's a bunch of issues there as well, right? Now you've got different disclosure rules. You got to keep the SIPA rules in mind, right? There's a whole nother set of regulations that come with that sort of thing. And everyone needs to be kind of mindful, obviously, of traps, such as people, who are using bots to drive traffic, people who are using illegal robocalls with illegal robotexts with tiny URLs, and they're driving through attribution sites to get to your website, right? There's lots of tricks and danger there too. But to me, that looks like that's probably going to be the future here post the NPRM.
Real quick, somebody did ask if this video will be sent to everybody. This will be posted at dnc.com. dnc.com stands for do not call. So if you don't have a solution for scrubbing a do not call list, please check us out. You can contact us at info@dnc.com. And Gallica, any final thoughts around, some people have mentioned the comments that there's a lot more risk to the buyer versus the lead generator or lead seller. Do you agree with that statement?
I mean, yeah, they're the ones at the end of the day, like they're the left holding the bag, essentially, right? They consumed that lead into their database, right? They're the ones that are probably dialing on it. So yeah, as I say, I think it's important that they have a really good compliance program at their company, or have someone consulting with them that can help them as far as even just vetting the vendors that they're working with and how those leads are coming into their system.
Yeah, I think, it's interesting to see how much further down the chain this is going to go. Are they going to stop where they're at now, or is this just phase one and then phase two is going to be digging deeper? I know that's been part of this is, trying to see who they can get a hold of the quickest. And I applaud their efforts to try to shut down bad actors. I think companies that are genuinely operating in good faith, or bad faith, I say good riddance to them. Thank you, FTC, for what you're doing. But, I think obviously, we need to take a look at what rules have clearly been defined. Have those been violated? And if you're out there, you're a buyer of leads, you're a seller of leads. Make sure that, or you're just placing calls to people that are in your existing lead ecosystem. Make sure everything's up to date from your data collection, your scrubbing, all of that. We are at the end of our time, so I want to thank our guests, Eric and Gallica. TroutmanAmeen.com is their website. There is also tcpaworld.com. They're available on LinkedIn. They speak in numerous events throughout the month, in person and virtually. So there's absolutely a million ways you can hear from these people and get some valuable information. So thank you so much for your time. Anybody whose questions weren't answered, I will do my best to get back to you as soon as possible, as long as you registered with an email address. You should be hearing from someone soon. Thank you, everybody, and have a great day.
Thanks, everybody.